Hi, everybody. Welcome to our Facebook Live for September. Today, we have a special guest to discuss a really important topic. So I'm joined by Tim Donlan. He's the principal of Donlan's in South Australia in Adelaide. So Tim and I'm really excited to have Tim come join us. We did actually work together maybe 18 months, 2 years ago. And I would say that Tim would have to be one of your go-to estate planning and trust specialist lawyers if you are in Adelaide. So I was really excited that Tim actually came to join us for this topic. Welcome, Tim.
Thanks, Tara. Good to be with you.
So this topic was inspired by an article that Tim and Katerina Piros wrote for the Taxation in Australia Blue Journal about this case, the Re Owies case. So I have actually boosted that in the Facebook group discussion. So if you want to get your hands on that, it's about 3 pages long, a really easy read to complement what we're talking about today. You can just download that and read it. And I'm really delighted, Tim, that you've actually come to talk to me as well, because firstly, this is a really interesting case. I think for me anyway, I feel like it kind of shifts the landscape for discretionary trusts, and I've had to readjust some of my thinking about trustee discretion and discretionary trusts off the back of this case and some of the other cases that are following this theme. And I really just want to make sure that we're getting the case and the principles from this case on everybody's radar. It is a long, lengthy case. There's a lot of moving parts in it. So we're going to try to actually break it down into 2 segments. So this first segment is going to focus on the aspects of the decision which relate to trustee discretion and particularly making discretionary income distributions. Next month will be a follow-up session just by me, where I'm going to dive into other parts of the decision around really just dotting your I's and crossing your T's about procedural regularity in trust and how important that was for this decision as well. So today we're just going to focus on the trustee discretion component, which I think will, that's more, an hour's worth to talk about on its own. And I guess just to summarize what we're really trying to do, my main goal for today is to get this on your radar, whether you're a lawyer, whether you're an accountant or even a financial advisor. I do think that this is a really important case for everyone to be across. So what we're going to do, Tim and I are going to have a bit of a chat about it. Before we start a general discussion, I thought it would be really helpful to talk about the decision and some of the facts and the principles that come out of it. I will just say, Tim and I can see your questions. So if you do have questions as we go, pop them in the chat. The more discussion and interaction we have with everybody, I find the better that these sessions are. So don't be shy on that front. Okay, so just starting at 101, and I've leveraged from Tim's article here in terms of some of the key principles. You know, historically, when it comes to discretionary family trusts, I've always thought that the trustee discretion is king, that they can really just do whatever they want, which is sort of true, but there are some long-standing guiding principles that the trustee has to follow when making or exercising their discretion. So obviously they are bound by the trust deed, and beneficiary entitlements are subject to the terms of the particular deed. We also have some general principles coming from the Gartside and Inland Revenue Commissioner decision, which basically confirmed that beneficiaries of a discretionary family trust do not have proprietary, legal, or equitable interest in the trust assets. Rather, their right is a mere right to be considered by the trustee when making distributions of income or capital, but they do have a right to insist on proper administration of the trust. So if you're used to dealing with discretionary trusts, hopefully this is not a new concept to you. We've also got the Karger and Paul decision from the 80s, basically affirming that The trustee's discretion has to be exercised in good faith upon real and genuine consideration and in accordance with the purpose for which the discretion was conferred. So, and the other part of that principle from Kaga is that if a trustee gives reasons for exercising their discretion, then those reasons can be reviewed. But if they don't give reasons, then basically the discretion can't be reviewed as long as it was made in good faith upon real and genuine consideration. So this real and genuine consideration component coming from that test in Kaga is what the case Re Owies has really focused on. And my sense, not that I'm a trust law expert, but my sense in previous cases is that a lot has focused on the good faith component, and real and genuine consideration has kind of been overlooked. But we're seeing a string of cases in the last 18 months, 2 years, which has really drilled down into what does real and genuine consideration mean. And this is something that I think as professional advisors and lawyers, we need to start bringing into our discretion and distribution documentation process. So let's have a look at how this played out in the Re Owies decision. And I have to say, I don't know how you pronounce the decision, Tim. Are you saying Owies or Owies?
I'm saying Owies. I don't know if that's
Owies.
right, but
okay,
I'll go with Owies.
Great, because I've heard it pronounced a few different ways, and it's anyway. If anyone knows for certain how it's pronounced, please correct us. Okay, so I basically got our family tree here. John and Eva, both doctors. Nuclear family. They had 3 children, Paul, Deborah, and Michael. And when the time of this decision started playing out in the courts, John and Eva were in their 80s, their 90s. That I think Eva actually passed away right before it went to the Supreme Court. And Paul, Deborah, and Michael are all adults, I think in their 40s or 50s. So the trust was set up in 1970, pretty significant capital value of 23 million, and it was earning hundreds of thousands, if not millions, of income every year. Throughout this entire period, they had a corporate trustee, JJE nominees, and initially the guardian and appointer was John, and then Eva as the successor. The beneficiaries, it had primary beneficiaries, which was just limited to the immediate family. So John and Eva and their 3 children. But then it did have that more expanded general beneficiaries class that you would typically see, which included the extended family and further lineal descendants. As I mentioned, there were issues relating to deeds of variation, trying to change who the guardian and appointer was. I'm not going to go into that today because it's not quite so relevant for the real and genuine consideration issue, but we will talk about that when we do the follow-up session next month. So effectively, from the 1970s, John and Eva were the shareholders and directors of that corporate trustee, JJE nominee. So they were in full control. Yeah, so Eva died in 2018 and moved into aged care in 2017. So she actually died sat before the Supreme Court in 2020. In around 2019, 2020, John's health was declining. He started his succession planning where he transferred his shares in the corporate trustee to his son, Michael. Michael was then appointed as a director. So basically, you'll see there's a real trend here where John and Eva have really favored Michael throughout the entire succession planning of the trust to the detriment of Paul and Deborah. So we're starting to see that in the succession planning as John and Eva's health is declining. Mr. Sampson was the long-standing family solicitor. So he was also appointed as a director in March 2020. There was some irregularity where he was purported to be appointed as a director in 2017, but that was not a valid appointment. So that was rectified in 2020. And then in 2020, John also died, and he was in aged care from 2015. The main crux of this is around what happened with the distribution of income and the trustees' discretion around distributing it. So from 2011 to 2018, they just followed the same pattern of distributions every year, where 40% went to John, 40% went to Michael, and 20% to Eva. And from what I can tell, that reduced amount to Eva was mostly because she had other assets, income-producing assets in her name, like I think a large share portfolio. So it was really just tax strategy planning that Eva was getting less. So you can see quite clearly there that the other two children were excluded from participating in the distributions. In 2019, after Eva had passed away, everything that financial year went to John, bearing in mind the income was about $1 million and he was living in aged care and had a very limited need for that income distribution. John and Eva also had really large, like multi-million loan accounts that they could draw on from the trust as well. Another thing just to bear in mind, so Deborah, the daughter, had been living in an apartment owned by the trust at South Yarra for many years. And in April 2019, they actually distributed that apartment from the trust to Deborah, and that was worth about $760,000. So in terms of the family dynamic, John and Eva were essentially estranged with each of Paul and Deborah. Michael was also somewhat estranged with his siblings as well. Deborah had ongoing chronic health issues essentially since she was at university. So she was at medical school, but just constantly plagued by health issues, was never really able to work full time, always on a pretty minimal income. So like that, she gave evidence that, you know, she earned about $40,000 a year, but her medical expenses would be about $20,000. She lived in this South Yarra apartment since 1984 and basically rent-free since 2006. Paul had a finance degree, ran his own successful business. In the early sort of years, he did get a little bit of help from his parents to finance a divorce and also the business. But around 2010, that relationship deteriorated, and really from 2014 to 2016, he had no relationship with them as well. So they were basically estranged, and we can see that in the distributions where Paul and Deborah didn't participate in those distributions. So what happened is Paul and Deborah brought an action to say that the trustee had failed to give real and genuine consideration to the income distributions. They only went back as far as 2015. It was sort of accepted that the limitation of actions stopped them going back any further. And what we've got is two decisions. So I've got the citations here. Basically, we've got the Supreme Court decision and then the Court of Appeal 2 years later. So the Supreme Court went through and basically looked at the distribution process for each year and said that in 2015 and 2016, they failed to exercise real and genuine consideration. And then on the Court of Appeal looked at that further, and for the years where the Supreme Court said that they did exercise real and genuine consideration, they actually overturned that and said, well, they failed on those years as well. So I know this is really text heavy. I'll try not to keep it too text heavy, but I do just want to go through some of the main themes or principles coming out of this. So firstly, these are some of the principles. The inquiry as to what giving real and genuine consideration of the beneficiary's needs has to happen. That needs to happen each year individually, so per beneficiary per year. And you have to appreciate the information available to the trustee at that particular time, but without distortion of information acquired in subsequent years, because often this is going back retrospectively. In this case, because John and Eva, the parents, were the directors of the trustee, they imparted information that they knew John and Eve had about Paul and Deborah's circumstances on to the trustee. The reason that in the Supreme Court decision that they held that in 2015 and 2016, no inquiry and therefore no real and genuine consideration was made is because there was just no contact with Paul and Deborah whatsoever. So obviously there couldn't have been any inquiry and therefore no genuine consideration of their circumstances. They reaffirmed what we saw in Kaga, that because the trustee did not disclose its reasons, the court could therefore not assess the adequacy of the reasons. And then going back to this concept of imputing information to a trustee, although you can do that by external information, there was no evidence in particular years that the trustee received any information about Paul and Deborah's circumstances. So I think it's a really interesting line, and this will obviously come up in nearly all family trust cases where, you know, we've got particular family members and their dynamic going on, but they're also controllers of the trustee. They also just looked into some of the fact that given John and Eva's living arrangements, they were in aged care, they had large loan accounts and sums available to them. They neither had really a need for these large income distributions each year. But that said, just because there was absence of a need for the beneficiaries who did receive the distributions doesn't mean that the discretion has been miscarried. In the Court of Appeal decision, they said, well, obviously, you know, you've got to look at the facts, so the size and scale of the trust, the nature of the relationships that might subsist, and the purpose of the power within the deed are all relevant. This is one I do want to talk about with, you know, to Tim. They said that where you have a potential large number of objects or beneficiaries, then the requirement to undertake a detailed analysis of the identity of each and the need of each beneficiary could be quite unworkable. But here they really just focused on those primary beneficiaries, being the 5 immediate family members. And in that case said, you know, that's not unworkable and inquiry really ought to have been made. They also looked at this sort of universal rule or standard practice of doing the distributions 40% to John, 40% to Michael, 20% to Eva. And they said a trustee may not divest itself of the continuing responsibility of real and genuine consideration each year by adopting a universal rule or acting under the dictates of another. So they said that in this primary judge's decision, the most important finding or what they relied on to show that there was a breach in those years was the lack of opportunity for the trustee to obtain information about Paul and Deborah because of the estrangement. Where the judge was satisfied that there had been some contact, he was not persuaded that the trustee ignored or failed to give real and genuine consideration to Paul and Deborah, but that was actually an unduly narrow view of the evidence. So when you look through the judgment, and it is quite lengthy, but it's not too difficult a read. You will see there's a lot of emphasis on the facts where some years they were fully estranged, other years there was some contact or some reaching out or visiting at the nursing home, but it wasn't really clear what information was imparted by Paul and Deborah during those events. So basically the trial judge said, well, as long as they had contact with them, then the trustees had a vague idea what was going on. But the Court of Appeal said that was too narrow of a view. In relation to the default entitlements of the beneficiaries, the Court of Appeal also gave this some weight. So because the children were the default beneficiaries in equal shares, this doesn't mean that you have to do the distributions in accordance with the default distributions where they're discretionary, but you do need to sort of just take that into account generally and the purpose of the trust. So again, another thing I want to talk about with Tim, because I found that not particularly helpful. So the Court of Appeal basically said no inquiries were made of Paul and Deborah's financial situation or their need. You really can't, there's no evidence to show that the knowledge that John and Eva had found its way into the deliberations of the trustee. And they actually doubted, because of these brief encounters, how much of appropriate and adequate information was transferred. It's not reasonable for a trustee to rely on the fickle nature of relationships between the family members as the source of information that it needed to discharge its very important powers under the trust deed. And because the trustee did not make inquiries of Paul and Deborah, the inescapable inference is that the trustee was not informed to an extent that it was able to make a genuine decision on real and genuine consideration. They also looked at that policy of the settled ratio or repeat distributions and said that that strongly points to a lack of consideration as well. So I'll just round up. So basically, Paul and Deborah were successful on appeal, but in terms of their remedy, they were not actually able to recover the distributions that they lost out on. And I think this is more on a technicality. So the court said just because the discretion was not made on a real and genuine basis doesn't mean that the distributions were void, because there were distributions made to valid objects or beneficiaries of the trust. The distributions were voidable, but basically when the initial proceedings were commenced, there wasn't an order sought to have them set aside, and Paul and Deborah's lawyers sought to amend the pleadings to seek that relief, but that was refused because they didn't bring it initially at trial. So I do think, with the benefit of this case, future decisions or future applications would probably seek that as a remedy, and they might get up on that. So it was more of a procedural reason why the distributions weren't able to be set aside and redistributed. But basically, we can't assume that failure to give real and genuine consideration will automatically lead to the decision being set aside and its consequences being reversed. On appeal, they were successful in having the trustee removed. So the Supreme Court initially said that the trustee should not be removed, but the Court of Appeal overturned that. And they basically said the trustee has demonstrated over a number of years a failure to act impartially, to give real and genuine consideration to the interests of Paul and Deborah, being two of the three primary beneficiaries. And the relationships between all of those beneficiaries involved is irreconcilably damaged. So it's not in the best interests of the beneficiaries. And they basically said, Michael has not demonstrated an ability to act impartially. So any trustee's control situation where Michael is the controller is not going to be appropriate moving forward. So basically, Paul and Deborah were successful in their application. And I think if they had brought a different or asked for the specific remedy of financial remuneration at trial initially, then they might have also been able to have those distributions set aside. So that's the facts. I know that's a lot to digest, but what I want to talk about now, I guess, with Tim is in terms of what does this mean for us as practitioners? Because historically, I've always said the trustee is the god of the trust. They can do whatever they want. They can exclude any beneficiary to the detriment of others. But following this decision, I really think we have to be much more mindful about being bullish on arguments like that. So, Tim, I've done a lot of talking. Would you like to share some of your thoughts?
Well, just going to that first bullet point you've got there about what's the standard now, I think that it really does send a message to trustees and their advisors that it's no longer appropriate to just have a standard formula, which was the case in Owies where it seemed to be every year it was just sort of some standard resolutions that were prepared, or seemingly maybe not even prepared in some years, but the distributions was just a default thing without any consideration. And I think that moving forward, trustees are going to have to go a lot further in not only considering but demonstrating that they've considered that, or given real and proper consideration, to use the terminology, considered all of the relevant beneficiaries. Now, whether that extends to every possible general beneficiary that might exist in a trust, well, it's probably unlikely because, you might not know who they are. The beneficiaries might not know who they are, but I think the argument is there that if a general beneficiary who falls within a class could come forward and say, well, I'm a beneficiary of this trust, consider me, I think the onus would then be on a trustee to actually consider that person. Now, I also think that trustees, provided that they go through a process, do have a large discretion. So the court didn't find that there's a set process that has to be followed, or that it's readily going to set aside distributions of income if it would have made a decision in a different way. But it's quite easy to see that if, in the absence of information, it's difficult for a trustee to say that they have considered a certain beneficiary, in the case of Owies, just without any information about those beneficiaries at all. So it does mean there's probably a bit less comfort for trustees moving forward.
Yeah, I agree. And I wonder, in terms of like the process, like, do you think that there's now a responsibility on a trustee coming up to the end of financial year to write to beneficiaries and say, please share your information about your need, which might include your financial situation, your health scenario, dependence on you, or is that too far?
I think it's open for that to be the path that we start to go down, because in some family situations you might not need to, because you might have that knowledge about certain potential, and I sort of restrict these comments, I guess, to the primary beneficiaries, if you like, so not just the general class. But in a family situation, they might know all about particular beneficiaries and what their circumstances are. In other cases, they might. I mean, I think we might get to that point where trustees, to safeguard themselves, actually have to make some inquiries where they don't know the circumstances of, say, a primary beneficiary or one of the primary beneficiaries, to actually be able to show that they have given real and genuine consideration. I think that goes to the hub of the decision. If you don't have any information about them, how can you possibly give real and proper consideration to them?
Yeah, and so I think, especially for the accountants listening, revisiting the documentation process that goes around those annual distributions, including, where do you need to seek extra information, or where's that information already held, and then making sure that's documented. And even in the resolution, sort of maybe saying these are the lengths the trustee has gone to this year to ascertain the need of each beneficiaries. It is obviously a case by case. Like, I think about for my family trust, where the beneficiaries are myself and my husband and our children. Well, and if I'm the trustee, well, then I know the needs of everybody. And I think, that knowledge can be imputed onto the trustee. But in these family, sort of broader family scenarios where you've got multiple, 10 people in a primary beneficiary class, and they are all doing different things, and there might be not a level of closeness, it is going to be harder to manage.
I think that's right. And I think there's also a bit of a balancing act there as well, because as we know, if the trustee offers reasons for the decision, then that can be reviewed by the court. So I think the best course for trustees is to inquire as to relevant information that they might need in order to give proper consideration to a beneficiary, and then reflect in resolutions that they've considered the relevant information. I think there's a real fine line there between saying, as a result of this, and this is the decision we came up to, because I think that would open a trustee up to some criticism and review. So it's a real balancing act between having the trustee be able to say they've received information that they need, and then disclosing that in the resolutions.
I always think about, where, like in this case, they basically wanted to exclude Paul and Deborah from participating in the trust. And in the past, I've said, well, you don't need to really bother excluding beneficiaries. You just don't exercise discretion in their favor. But that really didn't work in this situation. And I do wonder if it would have been a better path for them to just expressly exclude them. Although that said, I suspect the exercise of discretion to exclude them would have had this same real and genuine consideration test to it. Although it would have been a singular point in time test rather than, going over multiple years.
Well, it would have been yes, you could deal with it once rather than deal with it every year. But that's a good point. I mean, you could take steps to remove beneficiaries. The best answer is don't include beneficiaries that you're not intending to ever get a distribution when you set up a trust, because it's much harder to remove later on. There could be all sorts of consequences for that. There's equitable arguments, there's tax arguments, stamp duty, all the things that might come about from doing that. But when you're in a situation like Owies, the better, it's almost playing the game and going through the process, just to show that you've given real and proper consideration. But I think it's important as well that in situations where you've got families, and you probably use this as much in estate planning as what I do, is, for example, the farm, you've got one child who's on the farm who gets control of the trust, and it's almost treated by the family as that's his property or her property. And that's not how trusts work. They've still got a duty to go through and be a trustee and consider the other potential primary beneficiaries or other beneficiaries. So I think it's also a mindset about how we go about estate planning as well. It's a mindset for solicitors. It's a mindset for accountants at tax time, advising their clients about resolutions and going through that process as well. So I think this decision and the way the courts are going is going to make everyone, trustees and their advisors, a lot more cautious about how they proceed.
I agree, Tim. And in the estate planning context, I must say that this is sort of coming to mind, this decision, a lot more than and it's changed my strategy a little bit. So for those who don't know, in the TT Precedents Club, every week we sort of have a mastermind hot seat where people bring different scenarios to the group and we sort of workshop it. And I feel like if it's not every week, it's at least every second week that this real and genuine consideration test is being brought up now, in terms of just thinking really carefully about who we do include as beneficiaries of testamentary trusts now, instead of just sort of going, oh, well, we can just group them all into a single trust, or, put them in the trust and don't exercise discretion. But it also, as a double-edged sword, I think there's also advantages in terms of beneficiaries where there isn't an appropriate succession plan in place. It gives them a remedy or a right to be protected, where they can actually say, well, I did miss out on a distribution and I shouldn't have, so let's get this addressed. So I think there's pros and cons, but maybe this laissez-faire attitude of it's a discretionary trust and there's full discretion, which I have to admit, I have held that attitude for many years and been pretty chilled about the trustee can do whatever they want. I've really had to rein that in and reconsider going back to the core principles and saying, well, as you said, it's just because you're in control doesn't mean it's your asset.
No, and quite often people, if you give them a trust deed or a testamentary trust will, for example, and they say, oh, does this mean that this person gets something? And it's, previously the conversation has been, no, only if the trustee decides to give them something, and of course they don't have to. But that person who's the potential beneficiary can now cause some difficulties for a trustee. Well, they always have been able to in terms of accessing documents and just generally making the trustee's life a bit more difficult. But now with Owies and the way real and genuine consideration is going, I think they can really make the trustee's life a bit more difficult. So trustees just need to be on guard to that. And there's nothing to say the trustee can't make the distributions that they still deem fit, having gone through the process. They just have to go through the process, and it has to be real and it has to be genuine.
Yeah. Yeah. I mean, I found a little bit of comfort in the comments in the decision where, even though there was a broad general beneficiary class, both the Supreme Court and the Court of Appeal really just kept their analysis to the primary beneficiaries, because starting to look at, secondary and tertiary beneficiaries, it's a really burdensome process. But it does.
You got on mute. You've got on mute, Tara.
Can you hear me now?
I can now.
Oh, great. Sorry. So I guess what I'm saying is, how important is putting the purpose in the trust deed now and who to benefit? Because I've always tried to keep that pretty high level and not go into much of a purpose other than to provide generally for the beneficiaries. But that was something that was given a bit of emphasis in the decision. Have you changed how you're documenting the purpose of a trust?
Yeah, I have at times. I think that, for example, going back to the family farm, I've had a few cases where we're setting up a new trust. We know who's going to take over control of the farm and the trust in due course, and the trust, the way that it's the stated purpose is reflected is, it might be, it's to benefit people working in the farm or in the business. So I think that's going to take more relevance as well. So when the court, if a court was called on to assess a real and proper consideration, etc., we can go back, because that's one of the principles in Karga and Paul, going back quite a way. It's real and genuine consideration in good faith for the stated purpose of which the power was created or the trust was created. So yeah, I think that is going to become a lot more relevant when setting up trusts.
And I like your comment about setting up a new trust. A lot of clients will say, can we just use this old trust that we've got? And obviously there's historical asset protection and other compliance issues, but I think this just lends towards, why not start with a clean trust where you get the beneficiary classes really dialed in and the purpose right as well.
Well, it's not hard to set up a new trust. I mean, you know how easy that is. Why would you take on something that's got a history and it's got limitations when you can start fresh? I mean, it wouldn't be advisable.
Yeah, exactly. I think I don't know, clients just go, oh, it's another set of administration. But so it's, I think a lot of the lawyers are paying attention to this decision, but it's really something that has practical impact for accountants as well, I would say, particularly if you're sort of at the start of planning some of these succession planning exercises and the annual distribution resolutions, sort of just working with someone to increase the robustness of that documentation. I think that's going to be really important moving forward.
Absolutely, I think that's right, and I think that well, we keep saying it. It's no longer good enough to just have the set formula of who gets what every year on 30 June and sign off on that. That, I think, is going to be a thing of the past.
Yeah, I mean, I remember and I don't quite know what accountants are doing these days, but it was, for many years, it was standard practice that you would do the distribution resolutions. I think you had until 31 August or something like that. And then maybe 2018, the ATO said, no, you have to do them by 30 June. And, this is sort of imposing steps that mean you actually have to be much more organized, well before 30 June if you're going to be obtaining that information to have the real and genuine consideration. So it's all just about, those distributions have to become much less of an afterthought.
Yeah, I think that's right. And the other point that I would make is trustees actually need to understand what their role is, and the amount of clients that come and see us and have no idea about what their trust actually is and what it does. They know that it's something that was set up with the accountant however many years ago, but don't really understand how it works. And every year they say, well, we just sign off on the accounts, and yeah, I remember doing something about that. So there's really an education that needs to come out of it as well for trustees, so they do understand what their obligations are, because I think this area is only going to get more and more contested. There's going to be more and more challenges along these lines. So, what's the saying? Forearmed, forewarned is forearmed. So,
Yeah.
I think things are going to get need to get a lot more organised.
So, Tim, those are the main points that I wanted to make on the back of this decision. I'll throw it out to everybody. If you have any questions, we're here and we're able to take them, or commentary, or even just to share anything that you might think about changing. Tim, were there other points that you wanted to make that we haven't covered yet?
One of the cases that we'd referred to in the article when we wrote about Owies was the Victorian Marcella case, which was in relation to superannuation. So a different sort of element to it, because a closed class of potential beneficiaries of a death benefit. The point that I'd made in the article was perception is very important with all of this stuff as well for trustees. So when you've got lawyers writing hostile letters to potential beneficiaries, and this happens all the time in practice as well with litigation contested matters. If you're the lawyer and you write a letter to say there's no way in hell your client will ever get any distributions from this trust, etc., I mean, you're just opening yourself up to problems. I mean, that's not only going to lead to appointments of income, etc., likely to being set aside for not real and genuine consideration, but also removal of trustee, and that's going to be something that comes up more and more, is a removal of trustees that are not acting in the best interests of the beneficiaries as a whole. So, perception is important. If you're an advisor writing hostile letters to explain why this person's never going to in hell get a distribution from this trust in the future, probably not helpful.
Yeah, and actually that is a really good case to read as well, because it basically goes through very similar real and genuine consideration. I mean, I feel like there's been a string of real and genuine consideration cases that have come out, all sort of like compounding and relying on each other.
Yeah, and that's right, and it seems like the momentum is gathering for it. So in Marcella, it was quite evident, I think, to the court that the trustee wasn't giving real and genuine consideration when they were sort of saying, well, this person's not a beneficiary. So it also evident to the court that they didn't understand what their role was as a trustee.
Yeah.
So that was pretty dangerous, and that was easy for the court to say, whatever the distribution was, we're going to declare that to be void and you can start again. But moving into a discretionary trust like Owies, in that case, the court had found, it had introduced this concept of, was the outcome of the exercise of the discretion grotesquely unreasonable? And at trial it was found that it wasn't. But you can see cases where it quite easily could be. So in Owies it was found, well, some of these distributions weren't grotesquely unreasonable because the daughter had a right to live in the property for many years beforehand, etc. And we didn't know all the other circumstances, so it wasn't prepared to find that. But I don't think it's going to be a long stretch in certain cases. I mean, I'm familiar with just dealings in my own practice where we could say, well, that looks fairly grotesquely unreasonable as an outcome to me. So I think that's an expanding area.
Yeah, I definitely think this whole concept is a bit of a watch this space, which is quite good because I feel like we haven't had a heap of discretionary trust cases coming through. So it is always good to get these before the court and just to sort of reconfirm and reaffirm the principles. And obviously, it's such a growing area with the intergenerational transfer of wealth growing and growing that we're just going to see more and more disputes. I think I've basically made all the points that I wanted to make, and I can't see very many questions coming through. But Tim, if you've got more points, you're very welcome to take the floor. Otherwise, we might wrap it up shortly.
No, the only other point I would make is probably in terms of this as an expanding area of litigation. I think we all know that trust assets are generally not included in any IFP type claims, family provision type claims. But I think clever advisors are now sort of switching their minds where the estate might not be large, but the assets in trusts is more so, that this is an expanding front for those sorts of claims as well. So
Yeah, that's a great point. I'm pretty sure there was family provision application on foot against at least Eva's estate, if not John's as well. So
and
yeah,
the same in Marcella as well. So
yeah,
these things usually go hand in hand.
yes. Yeah. So I just think my main message is whether you're a accountant, financial advisor, or a lawyer, this is worth sitting down and having a good read of. Just a good recap of trust law principles as well as sort of understanding the dynamic, because I think once you start turning your head to it, you will see that the relevancy of this decision is going to come up for a lot of your matters, and it is something worth turning your mind to and basically staying on top of what's happening in the trust law space. So hopefully we've piqued your interest a little bit and given you a little bit of a background, and got you thinking about what can you do just if you're advising for family trusts, just to make that whole discretion process more robust. And if you're acting for disgruntled beneficiaries, sort of understanding some of the remedies out there as well. Any concluding remarks, Tim?
No, I think I was going to say we've covered everything, but we've probably only scratched the surface on all of the issues that were in Owies and all of these matters in general. So, no.
Yeah, look, I think we've
Thank you.
done a great job at doing a high level summary. It is pretty complex, and diving into each of what is the best practice for trustees protecting themselves. We don't really have the answers on that. We've just got the areas where problems can arise. So I'm really happy to keep the discussion going. If you're watching this as a replay, Tim and I are both in the group, so you can put in your comments and we can keep that chat going. Because I think this is an evolving area. So for everyone who was able to tune in live, I just want to say thank you so much for watching. And I want to extend a very special thanks to Tim for sharing his thoughts and his time today. And check out Tim's article that he wrote as well in the group, which I'll try to link to this replay. So that's it for us today. Thank you, everybody. And we'll see you all next month for part 2 of the Re Owies decision.
Thanks, Tara.
Thanks, Tim.